Good evening, ladies and gentlemen. For the organizers of this event, I would like to say thank you very much for honoring me to be one of the discussants and to sit and to hear about the very good work that I'm very much impressed with of one of my former students. So congratulations, Ndjodi. So I was asked, and the moderator said, John, we know you as being critical and objective, and so we want you to bring that to this forum. And I'm going to do exactly that. And of course, Ndjodi, being a scholar, knows that what I'm going to say is not because I'm petty or that I want to look whatever, but it's because this is the nature of academia. I'll start with my general impressions. And I'll start by saying it is reading the book, scan reading it, as you may want to call it, reveals that it is great scholarship. There's really no doubt about it. It reflects sound legal research and obviously hard work. Congratulations. It certainly makes a valuable addition, or it is a valuable addition to the existing literature, especially viewed from the vantage point that the right to water, and by extension, is viewed generally as a second-tier right in our constitutional dispensation. And I'm going to say, I'm going to clarify what I mean by that. And having said that, I want to jump in because, in my opinion, it's like the very fact that Ndjodi is saying that the right to water must be implied, must be read in from the right to life, basically says there is no express right to the right to water in the Namibian Constitution. And that is the problem. And that brings me to my first, I won't call it a critique, my first critical reflection on what was said. I get the impression, and of course, I was given the purview to look at it from a human rights perspective, because Ndjodi is writing very nicely about the first two chapters, about things that does not really fall within my, what do you call it, expertise, jurisprudence, and all those nice things that goes together with it. And I'm not going even to try to attempt to talk about that, because it's outside my expertise. I am, unapologetically so, a human rights advocate and a human rights defender, so to speak. So I'm bringing my critique from a human rights perspective, and I was given that leeway to do so. I get the impression, if you go to Chapter 11, if you go to Chapter 11 of the Namibian Constitution, it is called Directive Principles, no, not Directive, it is called Principles of State Policy. If you go to the Malawian Constitution, same thing, Article 13, it talks about Directive Principles of State Policy. And here comes my point. Reading through the very short part that deals with policies of principles of state policy, I get the impression that Ndjodi, or the author rather, maybe I should say the author, that the author is romanticizing something which was not supposed to be there in the first place. If you go, for example, to the South African Constitution, and you go to the Kenyan Constitution, and you go to the Zimbabwean Constitution, they do not have a chapter called Principles of State Policy. That the African Charter, in its preamble, is saying civil and political rights cannot be divorced from one another. So economic, social, and cultural rights in their very conception cannot be disassociated from civil and political rights. For that reason, the African Charter on Human and People's Rights is having one document that combines both civil and political rights. South Africa followed that example, Zimbabwe followed the example, Kenya followed the example. South Africa in 1996, finally, Zimbabwe in 2013, Kenya in 2010. Namibia in 1990 fell into the trap of seeing first-generation rights and second-generation rights. And Namibia, what I say here, what is the right word? Fell into the trap of what we call a bifurcation or bifurcation. What is the right pronunciation? A bifurcation of rights. Certain rights that are fully enforceable are part of Chapter 3 of the Namibian Constitution. And others that are not so enforceable are part of Chapter 11, specifically Article 95. The author seems, and they are called Principles of State Policy. The author seems to romanticize what I say, principles of state policy. The author seems to just find justification as to why the Supreme Court in the Molima case was wrong to say that actually the way principles of state policies are framed, if you read Article 95 and Article 101 of the Constitution, that the principles of state policies, as Article 101 says, unto themselves do not give you a right to go to court. And the author is justifying and saying, actually, the Supreme Court was wrong, that they misread what the article is saying. And I'm saying, I agree with all due respect with what the Supreme Court said. The reading of Article 105 together with Article 95 renders principles of state policy unenforceable. And I've got a practical example. If you go to Article 95, paragraph G, it says that the state shall enact policies and legislation that would give social assistance to the unemployed, to the poor, which is called indigent, and all those. But as we speak, there is no policy that talks about social grants for unemployed people, social grants for poor people. NGOs out there are calling for a basic income grant. None of them can go to the courts on the grounds of Article 95G. But you've got the mandate. You must enact laws and policies that would seek to uphold the welfare of the people. They won't have standing, as it mentioned, simply because no law has yet been enacted to implement that provision. And that is my take. The author seems to romanticize something which was not supposed to be in there. Because if if social grants were seen as rights, they would have been included in Chapter 3 of the Namibian Constitution. Article 95 talking about principles of state policy. That's one of my first issues that I'm having. Another one not so serious. The first one was much more serious. The other one yes, 5 minutes. The other one that I'm having an issue with is that the author is drawing very extensively from a report submitted by the Special Rapporteur on water and sanitation after her visit to Namibia in 2011, and then in 2012 she submitted a report to the Human Rights Commission. Good. Says everything that I would also say. But in the meantime, we had what we call other instruments, like the UPR, that took place in 2016. I haven't read, correct me if I'm wrong, the book does not make any explicit reference to the UPR session that took place in 2006. And the UPR session specifically addressed some of the issues that he's talking about. And Namibia is alerted to begin to address those issues of discrimination, the issue of long distances traveled by people, especially in rural areas. Also the issue that the water collection responsibilities fall mainly on women and girls. I know the Special Rapporteur also mentioned that, but much more recently, the UPR mentioned that, and I don't see anything. In addition to that, before I make my final point, in addition to that, in 2016, Namibia human rights record was also considered by the Committee on Economic, Social and Cultural Rights. There's a specific concluding observation issued on Namibia that is having several recommendations on the right to water and the status. And the book, again, you can correct me, the book doesn't address that. In conclusion, I'm saying, given the fact that it is a very excellent academic piece of work, it lays the foundation for all of us that are interested in human rights to do what the Special Rapporteur on extreme poverty is asking all of us to do. If it is a right, then it must be recognized. Recognized, in our case, not expressly in the Constitution, but of course he addressed that, but also recognized in legislation. So, as researchers, to what extent does Namibian legislation recognize the right to water? The second one, together with recognition goes the issue of institutionalization. To what extent are institutions in Namibia giving effect to the right to water? And institutions, we talk about local authorities, we talk about regional councils, we talk about the Ministry of Water, and what is the new name? The Ministry of Water and Agriculture. I don't know what, I know it's not the proper name. And lastly, to what extent, where there is a dispute on water, to what extent does the policy framework, the legal framework provide for accountability? Because rights are not there to be preserved, they are there to be enjoyed, as Ndjodi's book is eloquently stated. Thank you so much.
Now, I like the reading of the book. Everyone is attest to that. Much so because when you read an interesting paper or literature or book, you don't want to stop reading. You want to continue. And that's why I want to thank Dr. Ndeunyema for the good job. I knew him for some time. We shared the same bankers when we here studied bankers. But then with the book, I think from the initial starting point of the book, he lays a very good foundation. He situates the book properly, and much so he complicates the issue by saying that we need this scarcity of water. Yes, there are degrees of scarcity that he identified, but then he also goes to say that we have abundance of water, the body of water, be salt water or drinking straight water and so forth. But what I think lacks is the resources to transform or clean the salt water to be consumable water. Not for consumption, not for commercial purposes, but for that aspect. So that complication actually makes the issue even more interesting, because now you want to find the balance between the argument of having excess of water and abundance of water. I think this is where, again, the state policy in terms of development comes in, to say we have resources to do that. If we situate the right to water under Article 6, which is a very bold step in my view, because closer to what would have been imagined was to Article 8 as opposed to Article 6. So that leap of discussion transcending beyond Article 8 to Article 6 makes the reading also yes, complex. But apart from raising the good way, I was reading and I noted the following. They are very few. The first one is the duty. Under Article 6, when we look at the duty of a state or natural persons or legal persons, as they may consent to them, for example, to respect and protect. But then it is true we don't have the powerful men. But then if you go again to maybe Article deals with state policy, we talk about promoting and protecting, which makes that we have no standard in terms of the duty to the state. We need to come up with a formula of your own in order to see if that duty can be enforced. So I'm glad to see that you brought in the fulfillment aspect. That also draws on the work of, even though it's late now, Professor John Ragli, who is one of the international scholars. He dealt with the human rights and business. Now he looked at promoting, protecting, and remedying. So in my view, when I was reading this, as a follower of John Ragli, I noted the similarities of in terms of argument and one hand, and also the issue of remedy. But then to critique a little bit is the formulation of Ubuntu. From the discussion at page 40, I could not get the methodology that you attempted to bring forth in terms of when you say undo the past. When you say undo the past by re-invigorating Ubuntu, structurally you will recall in the past, the African, before the colonial era, women and children had no voice or platforms of discussion. So if you would not define the period when you want to reinvigorate this Ubuntu, then it becomes a challenge. Because naturally, in the past, was that Ubuntu existed without any memorial. So the order excluded certain class of people from participating. So I think what then is to say you need to have a time scale to say at what point of Ubuntu do you want to revive, you want to bring, because you're looking at African values that you want to revive. So that's one of the aspects I think that we need to iron out. And the other aspect is the question of the 4 pillars of Ubuntu that you brought forth. Yes, I fully agree to an extent with the formulation. However, I have difficulties with, if you look at the formulation, they are all, for example, community, there is solidarity, with interdependence. All this speaks about the collective. And only one possibility would signify some form of individualism. So the balance is not aligned in the view. Because if you look at the general principles of Ubuntu as is conceived, you'll find self-awareness there. You'll find issues like you are able to integrate with other people professionally. So the first 3 principles of the 5 deals with the individual, and the next 2 deals with the relationship between the individual and the next person. So if we could also try to get that balance in, I think it will do well. But the other issue also was the fact that the book says it's not situated within the social and legal perspective, that is the theme of the book. But then what you advance is actually something within the structure of the society. So the sociological aspect of Ubuntu is also still standing out within your book, even though you have a disclaimer to say the literature or the text of the book does not include social legal text. So I was of the view that if you were to expand it to say, maybe for next revision, if you were to expand it to say that within the sociological perspective, you will have the structure, the function, and of the society. So if we could include that within the discourse also, so that at least it enhances the discussion. The other aspect, which I wanted to maybe as a way of maybe thanking you, was to say that if you intend to bring the right to water under Article 6, and then you say, let's imply it, reading it from Article 6, which says that you have the right to life and no court shall in a way punish you by means of death or and so forth. But then the life aspect, which is in our constitution, is not the life of fulfillment in terms of dignity. It's life in terms of punitive sanctions which are drawn. So when you bring an aspect of water to life within our constitution alone, it brings a challenge, because then you are saying, for example, if you were to bring the migrants, or you were to bring the case we dealt with Lima, or you were to bring, just in relation to this, the Rotterdam case, how all this interrelate with your social and economic rights, and how they could be, in a way, be read into the Chapter 3. So this is where I could not also very well grasp as to what extent are you implying. I saw you wrote exceptionally well in terms of the content of the right to water that you want to bring forth, and the substantive aspects of it. However, I could possibly there's no writing which is exhaustive, because the procedural aspect which you bring and the justiciability of this, also I could not find how do you, if you advocate for Ubuntu, how do you now bring it in our court system which does not accommodate collective action? For the general collective, what measures or what steps what process, what methods should be used to bring that collective action. I think these are some of the observations. All in all, this is an exceptional work, and congratulations. I think it speaks for itself. That's why maybe you must give them a round of applause to say that it was passed without corrections. I think they've been working very well. Thank you.
Thank you, Dr. Masaki, for that critique and analysis. And by the way, by raising these pointers, we are not deconstructing. As academics, we always talk about value addition. I'm not going to ask you, Doc, to address all the issues. I'll just point to a few so that we allow the audience also to come in and raise their questions in the interest of time. So maybe what I'll just take perhaps one item from each discussant. From Mr. Nakuta, the UPR session, why did we not talk about that? And obviously, for the capturing of the right, we don't have it expressly in the Constitution. How else can we deal with it in the context of statute? So that's from Mr. Nakuta. And then from Dr. Masaki, perhaps let's look at the issue of Ubuntu in itself, how it's packaged or branded, discriminatory in a certain context if one wants to view it in a particular way. How do we deal with that? And then, of course, one question which is outside of this that I was asked to ask you, why Ubuntu and why not any vernacular term which is consistent with Ubuntu in the context of Namibia? I think those three should suffice.
Thank you very much, Dr. Harris and John, for those reflections. I feel like I've re-entered my PhD defense with an onslaught of critique, but I definitely accepted the greatest of spirit in terms of advancing the discourse. I can't but comment on the principle of state policy point, because this is a long-standing debate between John and I. I vehemently disagree that principles of state policy are a limitation on us implying socio-economic dimensions. I don't think it's a romanticization. I think it falls well within the dynamic nature of our Constitution. And in actual fact, John, you'd be pleased to know there is a publication, a journal publication that will be out on this very issue of directive principles. Hence the reason why the argument in the book is rather adumbrated, because I did not necessarily want to settle into the weeds of principles of state policy, because they're a bigger fish to fry, if you want. But on the UPR point, I definitely accept that perhaps a reference of an awareness to the UPR outcome would have been helpful for purposes of setting into context the book. But at the same time, I don't think it necessarily erodes the arguments that I put forward, because all those special rapporteur positions that I advance is just to offer the reader a contextual analysis of the water situation in Namibia, but the focus is much more normative rather than situational as such. But definitely I accept that perhaps I should have made reference to it, and I'll revisit that material perhaps just for my own awareness. And of course, judicial remedies. So the whole premise of the book is that, yes, you have all these special rapporteurs, the UN comes here periodically, the African Commission comes and says all sorts of things about the socio-economic situation, and then they go away, and then another 5 years, another report is produced, and many of the underlying themes are repeated. My argument is that the courts should be an enforcement, which can be both a carrot and most importantly a stick of accountability when it comes to these socioeconomic realities that can be individualized rather than generalized as it would inevitably be in a report of that nature. On Harris's reflections, also quite helpful, and trust me, there's been a lot of thought that has gone into the notion of Ubuntu. So on the last question first, why Ubuntu? So I do challenge that question directly in the book, where I trace the etymological origins of Ubuntu, and I rely on anthropology. So I don't necessarily see it necessary to reinvent the wheel, because there's already a rich anthropological literature that demonstrates that Ubuntu Kabantu is isiZulu, but Nu, Tu, Du, all those are linguistic variations of the same underlying value that cuts across African communities. And that notion of Ubuntu breaches the North Africa, Sub-Saharan Africa divide, in actual fact. I was indeed persuaded considering using a domestic Namibian term to give it more domestic purchase, but then which linguistic rendition of Ubuntu do you utilize in a multicultural, multi-linguistic context such as Namibia? I, for example, identify amongst the Twibu people of Kavango that they have a similar expression, or Baero people have a reference to Umundu, Menerovandu, and Donga people say Ontu Morantu. Should I then have recourse to my linguistic biases? But ultimately, Ubuntu has been referenced by the Supreme Court, the Constitutional Court of South Africa widely. It's a value that is accepted to be African. Even the Ugandan Supreme Court refers to it, as in the Kenyan Supreme Court and so forth. So it's known. It was a restraint on my part to avoid perhaps domesticating it when we're also moving in a Pan-African direction. The second point on Ubuntu, please remind me.
I think it's the time frame aspect.
Yes, the time frame aspect and those intersectional concerns. I'm acutely aware of it, but especially when I conceptualize re-invigorative constitutionalism, which is the umbrella under which Ubuntu falls, I use the textual anchorage of the Constitution, the right to culture in Article 19, which is a fundamental right to culture, meaning that I argue an obligation for your culture to also be reflected in the law, your values. The premise of Article 16, Article 66, pardon me, in terms of customary law and common law, customary law being on par with common law, customary law being recognized, but on par, but yet still being on the margins of the legal system. So this is an attempt to infuse our legal system with greater recognition, legitimacy, understanding, resonance with the local population. I'm not romanticizing, to use John's word, for example, customary law. I'm acutely aware of the fact that customary law, African values are limited. They are challenged. They are particularly prone to patriarchal norms, which subjugate women and children in society, as well as other minorities. And I carve that out through the scholarship that I referred to in terms of cultural relativism, rather than universalism in terms of values. So yes, Ubuntu has a positive manifestation, but at the forefront of our minds, I remind the reader that we should have an acute awareness of the potential misapplications of such values to subjugate already subjugated populations in society. Okay. So I'll end there.
I'll not belabor the point now. I'll open to the floor so that we can give you an opportunity to ask any questions.
Thank you, Dr. Ndjodi. My name is Konjeni, also LLB. Thanks to Dr. Ndjodi and Mr. John, our human rights lawyer. Third year, so we are all products of the school. Anyways, let me congratulate Dr. Ndjodi. He did a great job with his book. I want to come in with the angle of human rights and development policy, because my LLB research project was also on international human rights, on how to have the sustainable development goals also become enforced. However, I'm from the energy sector, and in the energy sector there's a tripartite that we say, the energy, water, food nexus. Now, this relates to development policy, but at the same time, it's also an instrument of human rights. So when Ndjodi says the courts can be used to enforce such rights, we also need to take into account what is the development policy aspect saying. Because if you enforce something which can't be done, who can be held accountable if the resources are not there? At the same time, if the resources are there, and say for instance, water is not provided for, who takes that accountability? So that's where the court can become beneficial. But at the same time, I always say that this literature, it must be incorporated into our African jurisprudence. Because when we did comparative law back then, we found that we are using a lot of Western literature into our frameworks for development. So let's take this learning curve into our African jurisprudence. We take into account Ubuntu, as it's been mentioned. Africa has got many languages, and all those proverbs have meaning. So if we have a law-making process, let it be applicable to our African jurisprudence. And let it also be an evidence-based approach, which makes it essential to justify policy formulation as a process before the legal enactment. Policy is key before legal enactment takes place. Thank you.
Good evening. It was a very great presentation. I didn't have a chance to peruse or to look at the blurb of the book, but from the critics and the presentation, I could pick up one important aspect, and that is the one of enforceability of these rights. As a chief human rights defender, I think that's the area where we must center our argument. I think Namibia is a very interesting country, and the Constitution is at the center of that aspect because it is international law correctly. As it was correctly mentioned, that the Untitled Chapter, which is the African Charter of Human and People's Rights, is signed by Namibia, which makes it part of the Namibian law. And then you go to the Constitution itself. Article 100 is of very interesting article in my view, because it states all natural resources belongs to the state. And it mentions water and sand and all those things. Now, when you have a right that you want to enforce, you can only enforce something that is entitled to you. Now, look at the meaning of Article 100. It says all natural resources belong to the state. The question is, who is the state? So if you look at the Montevideo Convention of 1933, it defines for you what's a state. And interestingly, it highlights three elements. And the rating is very interesting. First, it says it's the territory, and the second is the people, and the third is an effective government. So it tells you that the two elements, the first one and the second one, are actually the owners of the natural resources. So the territory is actually the land where you found the water. And then the people are actually organized themselves socially to give the right to the state to manage those resources. So who is entitled to the natural resources? Actually the people. So now come to the second aspect of mine is within the international law. If you can convict a citizen based on international convention for a crime committed based on that international instrument, let's talk about anti-corruption issues or terrorism issues, which is international conventions and those ones. Why can a citizen not enforce the right, which is also in an international instrument, in a domestic instrument? So those are issues that I'm throwing to the academics. I'm creating your thought to think how are you going to research on those ones to bring in the enforceability aspect. So maybe we can also enrich the work that Dr. Ndjodi already put on the table and add more flesh on it. Thank you.
Thank you very much. Sorry for my voice. It's nearly 41 years ago when I got into Oxford, and Professor Kachavivi was doing his PhD at St. Anthony's College on Woodstock Road. And it's absolutely delightful that a young man, 41 years later, strides into Oxford and comes out with a superb professorial book based on your PhD. Well done. Namibians, we are very bad at celebrating our own intelligence, and I think you deserve real honor for that. Now, I just started reading the book, and I was hoping that you would be defining life in the book, the initial stage. And I was hoping that you would define life both in the context of sociology and in the legal context as well. And I could see the tripartite relationship between Ubuntu, the law, and sociology as well. But I'm speaking a little bit on a medical background, because one of my theses in the master's law was on the end of life decisions, and where in the case of Anthony Blanc, and the same case as well with Lambert versus France, there was a question whether hydration constitutes medical treatment. And in order for us to think about an obligation on the state to protect life, you make reference to the duty in Article 6. But I was wondering whether there is a positive obligation on the state to protect life. We are talking about a positive duty, but does that translate into a positive obligation to protect life? And I'm not sure whether Article 95 is couched into a peremptory manner, shall, or whether it was discretionary. And unless we amend Article 6 to make a positive obligation on the state to protect life, we will still be having difficulties in translating the obligation of the state as a right to life for all of us. And then I was looking for a correlation between Article 6 of the Namibian Constitution and also Article 2 of the European Convention on Human Rights, which to a certain degree implies a positive obligation on the state to protect life. And that's basically my 2 points that I wanted to bring to you.
Differing with him on separate reasons not similar to those relied on by Ndjodi. And I wish to say this. First and foremost, Mr. Nabota, I don't know where you get this romanticizing concept from. Because if you listen carefully to the presentation of Dr. Ndeunyema, you'll realize that he says that the right to water is implied in Article 6. Article 6 protects the right to life. Once he locates the right to life, the right to water in Article 6, it's clear that the issue of justiciability is out of the question. So he definitely is not romanticizing Article 95 or the state policies. What I want to point out is this. When one excludes or includes justiciability, one must be very careful not to forget Article 66 of the Namibian Constitution. Because Article 66 of the Namibian Constitution puts customary law and common law at equal footing. But once you argue whether or not a particular right is justiciable based on common law principle, you make a fundamental mistake. The right to life, the right to water, is perfectly justiciable not only on what Dr. Ndeunyema points out as it is implicit in Article 6, which connotes the right to life, but it is also justiciable on the basis of customary law. If one interrogates, you will find numerous cases where the right to water is argued upon in communal courts. If I make an example for, if one has a water tank in the offense of land in communal areas, and your neighbor somehow denies you access to that, you can approach the communal courts for purposes of accessing that water. That is justiciability. So, yes, the doctor makes a perfect point that the right to water is justiciable on the basis of Article 6 of the Namibian Constitution. But my question is then, to what extent did he interrogate the justiciability of the right to water under customary law? Thank you.
My name is Hendrik Amutanya. I'm a legal student. To begin, I would like to congratulate you on your book. And I would like to ask you a question. It's a two-part question. The first part is, the language in this book is kind of, I observed, is kind of advanced. So how would we translate this? How would we translate this to the people in the rural areas in order for them to understand these matters? Because just by the way you are talking and the words in the language, I can see it's very advanced. So how would we translate it to those? So what safeguards do you recommend in these scenarios where water may be abused in a case where regulations are placed to help those in dire need of water? And just on a side note, I really appreciate the term you used in terms of Ubuntu, because me, myself, personally, I led a motion to the city of Windhoek asking us to have a discussion on the township Pretoria for it to be renamed, because I feel it has a bad connotation. And the word I used as a replacement, I suggested, was in fact Ubuntu. So I really appreciate you using that word. And, I really appreciate it.
Thank you very much. My name is Franz Gorike. Maybe
Yeah, go ahead.
okay, thank you. So it's Franz here. Thank you, Doctor, for quite a very serious and enriching presentation, and also piece of work, really. But I'm more looking in the presentation and the discussion, perhaps, from Marxist lens. I'm trying to understand if the idea, because there's this thinking that I'm over and over pondering on, that relating to the value, African value and culture. If the idea is to bring economy into the African value, if the idea is to bring somehow that process, I feel like it dilutes the spirit. So how best, even the idea of Ubuntu in this whole discourse of economizing Ubuntu within the domain of regal fraternity. So how do we safeguard the culture of African within that domain? If you see and synchronize history very well, for example, the economy of water, you make reference to privatization. Country like Finland, they don't have really market in the water, so to say. The state, in a way, is in charge. So it's not the same with us. We have this capitalist-oriented as far as water is concerned. So what I'm trying to put forward is a concern, perhaps, in how best we are going to safeguard our culture. Because the idea of translating our value even in university space or literature space, we are diluting the value of African. So unless I need to be guided, and that's really how that's the spirit and also a concern I have. Otherwise, really, I do appreciate the work. Thank you.
Thank you, Doctor, Director, for sitting. Mr. Gupta, my former lecturer. Ndjodi, I don't have a question or any comment to make. But when I noted toward the end of Ndjodi's presentation, Dr. Ndjodi Ndeunyema's presentation, this book was dedicated to Dr. Efa Okupa. And I remember Dr. Efa Okupa was one of the UNAM press lecturers. And she have always talked about how brilliant Ndjodi was. And that she introduced me to Ndjodi. That's why whilst Ndjodi was in UK, and I went there while he's in UK, I made sure that I meet Ndjodi. So the point I wanted to make here is really just to express my heartfelt appreciation. You have done very well. We have always been very, very proud of you. When we see Ndjodi, it's a great source of inspiration, and I'm happy that there could be some students here and some legal scholars, because what Ndjodi have achieved for Namibia and for the university is something that has not been achieved before, especially from the law faculty. If one look at the profile, those 4 degrees, those 4 postgraduate degrees in the PhD was completed within a period of 5 years. And Dr. Okupa, I think after you left, you were the son. I became the son after you left. And that's why at the memorial service here, I was chosen to speak on behalf of all her former students. But there was one point that Dr. Okupa taught us, is for us to use our brain cells. Who can remember the word? She always encouraged us to use our brain cells, because many people who come to school, we just want to memorize, want to read the case law and so on. But she was always encouraging us to use our mind, develop our mind. And it's also on that basis that I want to say that when we see Ndjodi, we must see inspiration. There have been people in the past who undermined or thought less of graduates from the University of Namibia. But what Ndjodi achieved at Oxford University is something that has not been achieved by many, many scholars from Africa who have gone to Oxford. And therefore, Ndjodi, once again, congratulations. I'm super, super proud of you. You being here, we are super inspired. And the future generation, when they come to UNAM, they will come to UNAM wanting to do law degree, because they are now inspired knowing that if Ndjodi can do it, to go to Harvard and be the best student, at Oxford, they can go to Harvard and other as well and be the best. So for all the other students and UNAM graduates, just know that be unlimited, you can be who you want to be, you can even do better than what our brother have achieved. So be unlimited. Thank you and congratulations.
I think there's a question from Kadida Momo, right, about justiciability and customary law, and then from Henrik Kamutenya regarding the issue of Henrika, that was what the issue of access, if I still remember, the language that is used, how do we get it to be simplified into the context of the ordinary people in that particular context? Because this is a fundamental message. And then I think after that, we can agree to close and allow the acting view. Oh, there's still another hand? Oh, okay. I thought Dr. Itula said his was a comment. You want a response, Doc?
No, I wanted a response on the positive obligation.
Oh, the positive obligation.
The positive duty.
Ah, okay, it's fine. Then Dr.
And the lack of definition of life in the context of Ubuntu and life in the context of law.
Super, okay, well said.
Because when you say life starts, one is the definition. But it's not a criticism. It's just a
no, it's value addition. It's important for such an exercise.
Thank you.
All right. So those are the 3 issues in that regard. Okay, Doc.
Okay, thank you so much. I think from the weight and quality of the questions and comments, I think I feel vindicated that this piece of scholarship has been taken seriously. Just to respond very briefly, perhaps I'll start with Dr. Itula's point.
So I regard, and I state this in the book, duties and obligations as synonymous. I use the language of obligations and duties synonymously throughout the book. I recognize that there's a jurisprudential gap in our case law, particularly because we barely get any robust engagement with these fundamental rights in our constitutional setting, and I think that's owed to some of the procedural difficulties that we face in terms of accessing our courts. Hopefully that can change, because you made reference to the European Court on Human Rights, as well as the European Convention, for example, Article 2. And there's so much jurisprudence meaning of Article 2, and it's always being developed, and so many dynamic aspects, whether it's surrogacy, or any of those issues that are being unpacked in the context of the Article 2 right to life. I would hope that such jurisprudence would exist in a Namibian context, and that would obviously be a natural port of first call, but it doesn't exist, hence the reason why many of the arguments that are advanced are normative arguments that hopefully will find judicial vindication through case law, which I think segues well to the point that Kadila is making in terms of Article 66, because I think Kadila, particularly being a practitioner of note, these are the sorts of arguments that hopefully they find persuasive and present before the courts, and then the courts have an opportunity to create jurisprudence that enshrines some of this underlying thinking. On the Article 66 point that Kadila raises, I'm not sure if you want to send me back to do a postdoc on that subject matter, but it's very interesting to think about it, even if it's in abstract, but I must say that I did want to anchor my right to life in Chapter 3 in order to give it the permanence of Chapter 3, and also perhaps relating that back to a point that Dr. Ndeunyema made in terms of the Constitution. I think there's also potential to amend the Constitution in favor of socio-economic rights, because Chapter 3 limits one from derogating from Chapter 3, but there's nothing that prevents us from adding to Chapter 3. So a Article 6 bis, for example, which articulates socio-economic imperatives as we've seen it in Indian jurisprudence, which then gave rise to the political commitment to amend the Indian Constitution, because implied rights were effectively recognized by the courts, and then it was just a foregone conclusion that the political process would see to it that they were expressly mentioned by way of amendment of the Constitution. So yes, sometimes, especially when we discuss Chapter 3, we focus on, Article 16 is a limitation because we can't expropriate without compensation, but there actually are things that we can do. Let's perhaps contemplate adding these socioeconomic dimensions, which I think were an oversight at the stage of constitutional history, of course, at the time of 1998, 1989, when they were drafted the Constitution. The world wasn't there yet in terms of recognizing them, but there's nothing that, in theory, prevents us from remedying that omission. On the accessibility point, so the first step of accessibility is actually being able to access the book, and that is the reason why I was dissatisfied with the prospect of my PhD remaining in the Bodleian Library at Oxford University and accessible only to a select few, and hence the reason why I did the arduous work of producing a book out of the thesis, which in itself is a few steps ahead in terms of getting a publisher and finding the time to do the work and so forth, and still being subjected to peer review and so forth. So I see the book as being hopefully a tool that people can use in order for them to vindicate their own rights. So it's a tool book that hopefully can be utilized by those who are particularly curious So curiosity being key, especially if there are linguistic barriers and so forth, which I would be surprised if there are for a law student. You know, if you come across a term that you haven't seen before, the natural point of departure is for you to understand that term before you move on. So hopefully that is the premise upon which you receive the book, and it's not necessarily my individual responsibility, I suppose, to translate this to the communities out there, but we can all be the agents of Ubuntu through water in our communities, given our levels of sophistication, and hopefully we can, in so doing, bring greater understanding and knowledge and dignity to the lives of everyone. And perhaps as a concluding point, as reflected by Lesem Shibute, in terms of the inspiration point, I value those words as well as the various words that were shared around the audience. I do not take them for granted, and I think there's a lot of potential that lies within us that stands to be manifested. And in my own journey and the privileges of opportunity, which met ambition, interceded by abundant grace, with anything to go by, I think it's demonstrative of the potential that we have as UNAM scholars, UNAM graduates, Namibians, as Africans out there, to be relevant in the world, not to regard ourselves as people from small countries that are irrelevant, but people who can make a contribution on the global scale. And hopefully the message of Ubuntu through water is one that is a metaphor for such possibilities. So that I'll conclude there.
All right. Well, as I said, it's really a good read. It's scholarly work done, and I can also just once again repeat what I said. Congratulations, Johnny. It is a great source of reference. But I would also like just half a minute said, Amomo, you totally misunderstood what I said. I did not mean to say that the right to life or the right to water is not justiciable. In fact, all human rights are justiciable. What I said primarily was that we were not supposed to have Article 95 in our Constitution. That's really the premise of my thesis. And I'm saying that Ndjodi, of course I use the word romanticize. If you were to go to page 191 in the book up to 206, you get that impression that I'm getting. And so it is not from this presentation. So go and read that pages and see where I'm coming from. So thank you very much.
Thank you. Just a quick reflection on the Ombudsman's question of Article 100 and then the enforceability of international instruments, where he asked whether someone can actually rely on an instrument which is outside of international instrument. I think the first thing to look at is whether the instrument is self-executing. For example, the general comments which are referred here are not self-executing, which means it will be harder for you to really bring them into our courts. That's one. The other one is that, notwithstanding the fact that it's not self-executing, you still have leeway. I don't want to speak about Article 144 because it's very common, but there are leeways to which you can persuade the bringing of such articles into our system. So, in a nutshell, I just want to thank Dr. Ndjodi for a well done job. Thank you.